Hello and welcome to No Holding Back with me, Susan Estridge. Each week I'll have the privilege of talking with some of the biggest names from the worlds of media, politics, and law. Nothing is off the table. I'll be speaking my mind and encouraging my guests to do the same. Today I'm joined by the smartest person I know on the subject of constitutional law, and I know everybody. Erwin Chemerinsky is a friend, a teacher, a colleague, a mentor, but friends first. He's just one of the most wonderful, well-regarded scholars of constitutional law. He's the dean of Berkeley Law School. He was previously the dean and creator of UC Irvine Law School. Even before that, he was my colleague for 2 decades at the University of Southern California Law School and at Duke University Law School. He's written the most important books about constitutional law of our time, and there is nobody better to talk to about the Supreme Court this term than Erwin Chemerinsky. Erwin, thank you so much for coming back to No Holding Back.
Thank you, and thank you for that incredibly overly generous introduction.
Well,
It's
it's
so
all
wonderful to get to
true.
talk. It's just wonderful to get to talk with you again.
It's wonderful to talk to you and such a timely discussion. I can't believe what's going on with the Supreme Court. Let's start with the immunity decision and then go from there. Erwin, what is happening?
I think the Supreme Court's decision on July 1st in Trump versus the United States were regarded by history among its worst. The
That's
Supreme
really
Court
something to say.
broadly said, it is. I think there is a hall of shame of terrible Supreme Court decisions, and Trump versus the United States will be on that list. The Supreme Court said that a president has absolute immunity from criminal prosecution for anything done in carrying out the powers of the president under the Constitution or a statute. As Justice Sotomayor pointed out, if the president would order the Navy SEALs to go and assassinate somebody, a political rival, absolute immunity because the president's commander in chief. If the president were to use the Justice Department to politically prosecute somebody for retribution, the court was clear, absolute immunity, and the president's motive doesn't matter. Remember President Nixon using the IRS to investigate his political enemies, absolute immunity. If the president were to sell pardons, and you might remember a former Illinois governor who tried to sell an appointment to the Senate, absolute immunity. And even for things at the outer reaches of the president's power, the Supreme Court said presumptively absolute immunity. The court went so much further than it needed to, or that anyone expected it would go, in giving absolute immunity to the president.
Why, Erwin? I mean, John Roberts has always had a reputation as a institutionalist, as somebody who cared about the institution of the Supreme Court and somebody who was not simply a partisan. Why did he go so far?
I We're only speculating at this point. My surmise is it's the only way he could write a majority opinion. At the oral argument, Justices Thomas, Alito, Gorsuch, and Kavanaugh all took this position of broad, absolute presidential immunity. I think that Justice Barrett, as she indicates in a concurring opinion, would have been willing to take a much more moderate approach. And of course, Justices Sotomayor, Kagan, and Jackson dissent. But had Roberts gone with Barrett, it would have been a 4-2-3 split without a majority opinion. And I think Roberts wanted to write this case. And the only way he could write the majority opinion would to do it this way, because the only way you get to 5 votes.
Yeah, but that's absurd. I mean, he could have gotten to 5 votes with the three dissenters and him for a more moderate approach. He could have written the controlling plurality, not plurality, but the controlling opinion in the case to create a majority. He chose not to. Why?
Now, it may be that Roberts really believes the position that he took.
That's
And
the
though
scary
you're
part.
correct that Roberts is generally a minimalist, want to decide narrowly, an institutionalist, this opinion is anything but. Roberts began his career after clerking, working in the Reagan office of the White House counsel. And he's indicated a belief in broad presidential power. Yet my instinct is here that he went further than he might want to have gone because that's how he got a majority opinion, not a fractured court and a plurality opinion.
What does this mean in the Trump case itself? Is there anything Trump was indicted for doing that would not qualify as presidential absolute immunity under this opinion?
I think the answer to that is clearly yes. There's really four things that were the basis for Jack Smith's indictment. One was the communications with the Justice Department. That the court rules on and says is absolute immunity. A second is the president talking to Vice President Mike Pence to try to throw the election to Trump in counting the votes in Congress. The court said that's within the scope of presumptive immunity. But I think there's a strong argument that what the vice president would be doing wasn't really anything to do with carrying out the powers of the presidency. The third is President Trump pressuring state election officials, like in Georgia, to find additional votes for Trump. And the fourth is what Trump did relative to January 6th in the insurrection. I think that neither of those fit within even the outer reaches of a president's power. So neither of those would be in the scope of absolute immunity. And for that matter, I think the convictions in New York authorizing the payment of hush money and lying about it in terms of business records doesn't fall even in the outer reaches of presidential power. So I don't think that the decision should have any effect on the New York convictions.
So why did Judge Merchant in New York put off sentencing of Donald Trump until September to hear the argument? The way I heard Trump's lawyers were putting it, because he signed the check in the White House. I mean, that cannot be right. That you sign a check in the White House for the private payment of hush money about sex that you had 10 years before. How can that be presidential power?
It isn't, and it can't be. I think what the judge did was say, Trump's lawyers made a motion based on the Supreme Court case. The judge, I think, appropriately said, I'll hear arguments on the motion. But the Supreme Court creates three zones where the president is clearly exercising official authority under the Constitution or under statute, absolute immunity. Where the president is the outer reach of constitutional authority, presumptive immunity. But where the president is acting in a non-official or private capacity, no immunity. And it's no immunity even if it was done while in the White House. Authorizing the payment of hush money occurred before the election. Covering it up by falsifying business records occurred when he was in the White House. But by no stretch of the imagination is that carrying out a power of the president. So I think the New York judge will and should rule under what Chief Justice Roberts said, no immunity.
Erwin, why couldn't the court have gone through the acts that are the subject of this indictment and made a decision itself rather than remanding to the district court? And then what I'm afraid of is you're going to have fights in the district court as to what counts as a presumptive and what counts as absolute and what counts as no immunity. And no matter what the district court decides, Trump will appeal it to the DC Circuit and will be off to the races again in terms of not having a trial until, God help us, Trump is president.
I think you're right. I think this is one of many ways in which the conservatives, the Republican appointees on the Supreme Court, have handed Trump a huge victory. The Supreme Court could have heard this case in January when it was requested to grant review by Jack Smith. It didn't do so. It could have expedited decision after oral argument on April 25th. It didn't. It waited July 1st for its decision. This was an enormous victory for Trump because it makes it almost impossible that there'll be a trial before the November election. As to some of what's in the indictment, it is so clearly beyond even the outer reaches of presidential power. So, for example, asking election officials, such as in Georgia, to find additional votes can't conceivably be thought of as an exercise of presidential power. The court could have said there, this is not protected by immunity. But the court sent it back to the district court instead. And the result of that is there'll be a hearing in the district court, a ruling. There might again be an appeal to the DC Circuit, review sought in the Supreme Court, all of which makes it impossible there'll be a trial for a long time to come. And keep in mind that if Donald Trump is elected in November, he could try, once he takes office in January, to pardon himself for any of these federal charges, and the federal charges in Florida. He can't pardon himself for the New York State convictions, only for federal charges.
Erwin, what's to stop a cynic? I mean, I try to give the court the benefit of the doubt. Like you, I have always cared about the Supreme Court and cared about the rule of law and the very idea that the Supreme Court's legitimacy matters. But what's to stop somebody from now concluding that this court is simply another partisan institution which doesn't deserve the respect of the people?
The ideology of the justices, as you know so well, has always mattered in the decisions. The reality is that six Republican appointed justices gave broad immunity to a former Republican president who's a candidate for public president. I don't think anyone should ignore that political reality.
What does that mean, though? I mean, does that mean we should, I was never one who was in favor of tinkering with the court when people said we should expand the court or we should set up term limits. I was always concerned that if the court becomes the subject of partisan manipulation, it would bite us all in the rear end. But now I'm of the view that if there's anything you could do about this Supreme Court, you should do it because they don't deserve the respect. And that's a sad position to be in.
The Supreme Court has its lowest approval ratings in history. There's much that contributes to that. The ethical issues certainly are part of that. Overruling Roe versus Wade is part of that. I have long favored term limits for Supreme Court justices, and I can certainly explain why. I think expanding the Supreme Court is a harder issue, but it's also not politically possible given Republicans' control of the
Right.
House of Representatives. But what we've got to accept is that because of the 2016 presidential election, there is a conservative majority on the court, and it's likely to remain that way for a long time to come.
And so, what's to be done? The Supreme Court just falls into further disrepute. It keeps handing down. We should talk before we run out of time about a few of the other decisions. I mean, I don't know what to make of what's going to happen to the EPA and regulation and the environment with this Supreme Court. They've issued a number of decisions this term that really trouble me. Obviously, Trump is the worst, but what are the others, Erwin, that we should be concerned about?
Well, I'll take your example of the administrative law cases. There were two decisions this term that dramatically changed the role of administrative agencies. And I want to make this concrete, not abstract. This is about the ability of the EPA to protect the environment. It's about the ability of the Food and Drug Administration to protect consumers from unsafe drugs. It's about the power of the Department of Agriculture to make sure that our food is safe. It's about the power of agencies to regulate businesses to protect consumers. One of the cases was Loper Bright Enterprises versus Raimondo. And it involves what's been called the Chevron doctrine. It comes from a 1984 Supreme Court case that says that when an agency is interpreting an ambiguous statute, courts should defer to the agencies if they're reasonable. Again, to make this concrete, the Clean Air Act says that the EPA can regulate air pollution. Imagine that the EPA says that only so much of a particular pollutant can be put in the air. Courts under the Chevron doctrine would say, we defer to the EPA. They're the experts with regard to air pollution. What the Supreme Court does in overruling Chevron is say, no longer should courts defer to the EPA. No longer should courts defer to the Department of Agriculture in regulating foods or the Security and Exchange Commission in regulating businesses. What businesses long wanted was to have Chevron overruled could make it easier for businesses to challenge agency regulations in court. And a conservative pro-business court gave them exactly that. The other case that didn't get media attention, but it's going to also be important, came down the day before on June 27th. It's a case called Securities and Exchange Commission versus Cherkesy. And it involves whether a federal agency can impose fines and penalties. There are over 200 laws that give agencies the power to impose fines and penalties. For example, the Occupational Safety and Health Administration can impose fines on businesses that have unsafe workplaces. The Supreme Court said no longer can agencies do this. They have to go to court in order to do this. Besides a huge shift from agencies to courts, there are some agencies like the Occupational Safety and Health Administration that don't have the authority to go to court. Their only authority is to impose fines within the administrative process, and no longer can they do that. This, again, is a huge victory for business and a huge loss for consumers, for all of us.
And that again is ideology triumphing over precedent over respect for what has been the rule of law, and there's nothing to be done, right?
The decisions were both 6-3. Chief Justice Roberts wrote both. Justice Sotomayor wrote the dissent in one. Justice Kagan wrote the dissent in others. And the problem is, since they are interpreting the United States Constitution, at least with regard to the latter case, Jerkezi, there's nothing to be done. The former case on Chevron deference did overrule a 40-year-old precedent, but it was interpreting a statute, the Administrative Procedures Act, not the Constitution. So Congress, in theory, could reinstate Chevron deference by changing the Administrative Procedures Act, but it's so inconceivable that this Congress or an immediately foreseeable Congress would do that.
It's a very depressing picture. What's the future for the Supreme Court? I mean, what happens when the Supreme Court's public approval level is this low? I was reading an article about teaching constitutional law and how it's changed because the way we used to teach it, the way it was taught to us, the way I'm sure you and I both taught it, was the Supreme Court opinions were worth paying attention to as law and as interpreting law and as learning the limits of law. And ideology always mattered, but there was some notion that precedent mattered too, that the Constitution was a living document and had to be interpreted in changing times. And now we seem to have a situation where what do you teach your students? That there's nothing but politics?
Let me take your two questions in reverse order, starting with the latter. What I teach my students is that it's important that they know these doctrines and rules because those are the ones they're going to have to use. They're going to be litigating in state courts and federal district courts and courts of appeals, rarely in the Supreme Court. And the judges, for the most part, will try hard to apply the Supreme Court's doctrines. So they need to learn those doctrines. Now, then we can talk about what's the basis for them. But I want my students to see that the Supreme Court's decisions have always been a product of the ideology of the judges. Now, in terms of your former question, what about the future of the Supreme Court? Keep in mind that Clarence Thomas is 76, Sam Alito is 74, John Roberts is 69, Gorsuch, Kavanaugh, and Barrett are all still in their 50s. It's easy to imagine that these justices will remain on the court for a long time to come. But I think that the next election in November 2024 is going to matter because I think that if Donald Trump wins, Thomas and Alito will retire and let Trump pick 40 or 50-year-old conservative to replace them to keep those seats in conservative hands for another 30 or 40 years. So the chance of changing the Supreme Court's composition so turns on presidential elections. As I said to you earlier, imagine Hillary Clinton had won in 2016 rather than Donald Trump, and that she had picked 3 justices rather than Trump. Roe versus Wade wouldn't have been overruled. The cases we talked about today wouldn't have been decided the same way.
It's unbelievable. And, in the days, I don't know what'll happen in this election. In the days when I used to do politics, we never could get people to vote on the Supreme Court. I think now that may be different. I don't know. I have to ask you,
Republicans,
what do you think of Biden right now? Because I so trust your opinion, and I'm so curious to hear what you think of the
sure.
situation on the Democratic side.
Let me again take what you say in 2 parts. The first is Republicans tend to vote on the basis of the Supreme Court and judges much more than Democrats. In 2016, according to CNN exit poll, the number one reason Trump voters gave for their selection of Trump was the Supreme Court and judges. For Democratic voters, number 4 on their list for voting for Hillary Clinton was Supreme Court and judges. I think we have to find a way to get the message out. The most long-lasting effect of any presidency is who the person puts on the Supreme Court. As to the latter, as to Biden, of course, I don't have any special expertise. Prior to the debate on June 20th, June 27th, I would have said that I thought that Biden should remain as the candidate. After watching the debate, I'm among those who believe that he can't be the candidate. It was a performance that I think left 52 million people who watched with grave doubts about his ability to be president. I think that the Democrats need a different nominee. And as I say, I totally changed my mind after watching the debate. Where are you on the question? You've run a
I'm right
presidential
with you.
campaign.
I watched the debate, and it was painful. It broke my heart because I've known Joe Biden for 40 years. I think he's done a fine job as president. I think if he stepped aside, people would remember him as having been a very successful president. But the man who I saw on the debate stage, I didn't have trust could do this job for the next 4 years. It wasn't just a 90-minute performance. It was an insight into where he is mentally and physically at this point in time. And the question was not whether he had a bad 90 minutes, but whether people can have confidence that he can serve for 4 more years as an effective president.
I agree with you. In 2014, I wrote an op-ed in the LA Times urging Ruth Bader Ginsburg to retire that summer.
Yep, I
I said, there's a
remember. And you took a
Democratic
lot of hate
president.
for it.
I did. And ultimately, she
You were
gambled
right.
and we lost. Joe Biden will be gambling if he runs for president in 2024. And I think the stakes in this presidential election are so high. I think that the future of our democracy could, and it's not hyperbole, rest on this election. I just don't think we can accept that gamble.
You have a candidate. What do you think of Kamala? You're up at Berkeley, you're in her
Sure.
district, you're from her world. What do you think?
I think she should be the nominee. I think that she's the heir apparent as vice president. I think there would be terrible political consequences for the Democrats to jettison the first Black vice president. I think when you look at where the swing states are, Michigan, Wisconsin, Pennsylvania, Georgia, Nevada, Arizona, I think she could be a real asset for the Democrats. Also, I think she's a very charismatic and effective speaker. She'd be terrific against Biden in the debates. To give one example, a crucial issue for the Democrats has to be abortion.
Right.
And this was the place where I thought that Biden could really get an advantage over Trump because it was Trump who said he was going to appoint the justices to overrule Roe v. Wade. And Biden gave a terrible answer on abortion. I don't think
Terrible.
Kamala Harris would have.
No, it was a terrible answer. I mean, the truth on abortion is, no state allows a 9-month abortion and a live baby to be killed. I mean, that's homicide in all 50 states. And I don't know why Biden couldn't have just said that. Okay, you've been listening to No Holding Back with me, Susan Estrich. Thank you to Erwin Chemerinsky, as always, for a great conversation. Tweet us at No Holding Back FM, and if you enjoyed this episode, please share the link on social media. You can sign up to receive an email when a new episode drops at our website, noholdingback.fm. Again, thank you, Erwin. You are terrific as always. It's been such a pleasure to talk to you, and I'm sorry to say I agree with you about everything. So thank you for listening, and I'll see you next time on No Holding Back.
Thank you so much for having me. It's always wonderful to talk with you.
Thank you, Erwin. You're the best.